Thank you very much, Judge. Good afternoon, everybody.
Good afternoon.
I hope you can hear me well.
We can hear you, my lord.
Oh, thank you. We are going to do a hybrid so that we utilize the tools we have, including technology, for swift delivery of justice. The matter before us today was for highlighting of some issues, which was agreed upon by all the parties. And after wide consultation and consensus building among us, ourselves, and the parties. And we realized the urgency of the matter, hence today's date. So I hope everybody is ready so that we can continue with the highlighting and complete the matter with the speed that is required of us as ministers of justice. So I'll call upon Senior Kalonzo to introduce his team.
Thank you, my lord, my ladies. I appear together with my colleague Eugene Wamalwa, Council Soyinka Lempa.
Present, my lord, my
We are
ladies.
so happy he's not appearing virtually. He has always had some difficulty, but he's here physically today. Councilor
Right.
Wanjiru is also on record, but he's traveling between Nairobi and Kilifi. Should he catch up? He's also on record, my lord, my ladies, and Councilor Stephen Zaku.
Yes, my ladies and my lordship, I'm present.
That's okay.
Okay. All right. John Ohaga.
Good afternoon, my lord.
No, there's Professor Ogola. Sorry for that. Professor Ogola.
I haven't seen him this afternoon, my lord.
Okay. So Professor Ogola, we mark him absent, eh?
There were two other petitioners.
So Professor Ogola absent. The other two petitioners.
Samuel Kahara Masharia, petitioner number 4.
Karanja is present.
Kahara Masharia. Samuel Kahara Masharia. Yaona.
Okay, Kahara Masharia. All the petitioner present.
Present.
Yes. The other petitioner. The other petitioner is absent. All right. Now we go to John Ohaga and your team. Please introduce them.
Good afternoon, my lord. Good afternoon.
Good afternoon.
Good afternoon, your leaderships. I appear together with Mr. Christopher Malwa
Yes.
and with Miss Leila Ahmed.
Miss?
Miss
Miss
Leila
Leila.
Ahmed
Okay.
for the first, second,
Second,
third,
third,
I beg your pardon, first, second, fourth,
not third, eh?
not
Fourth.
third, not third. First, second, fourth,
Yes, fourth,
fifth,
fifth,
ninth,
ninth,
10th, here for the sixth respondent.
sixth respondents.
Mrs. Aisha Abdallah,
Aisha Abdallah.
appears for the seventh respondent.
My lord, together with Mr. Mayo,
Together with Miss
Mayo.
Georgina Amayo, together with Miss Georgina Amayo.
Okay, Miss Amayo. And Ms. Aisha, there are for 7 the respondents.
That's right, my lord.
Yes.
And Mr. Kevin McCourt, senior counsel,
Yes.
appears for the 8th respondent.
Court physically.
Okay. Present. Yes.
Any
Any other representation?
covered all the parties? I think I've covered all the parties appearing, right?
All right.
No, my lord, there's still the 12 respondents. But
Mr.
My lord, yes, Mr. Ismail.
reasoning.
Mr. Ismail is present for the 12th respondent.
Ismail for 12 respondents.
My lord, we are
Yes.
on our way to court physically.
Yeah, no problem. So Ismail for 12 respondent present. I have marked him.
Thank you very much, my lord. That's
Okay.
the appearances for the respondents.
Okay. All right. Today was for highlighting of submissions. Senior Kalonzo, are you ready on your part?
Yes, my lord, we are ready.
John and your colleagues?
I beg your pardon, my lord.
I'm saying John and your colleagues, are you also ready for highlighting?
Yes, yes, we're ready, my lord. We are ready.
Okay.
Thank you.
So, Senior Kalonzo, how much time do you think you require to complete your submissions?
30 minutes, my lord.
30 minutes.
We propose to proceed in the following manner, my lord, my ladies. I will make
Yes.
some opening remarks,
Okay.
and I will leave Council Lempa to do the detailed presentation or highlighting.
Okay.
As soon as I'm engaged, my lord, my ladies, I will quietly exit. It should not be seen as a mark of disrespect to this court.
All right.
And so we are ready to proceed, my lord.
Okay. That's quite in order.
So,
So, yes, you can continue.
thank you, thank you,
Proceed, Senior Kalonzo.
thank you. My lord, my ladies, it is not lost on the petitioners that following your ruling which granted the petitioners conservatory orders,
Yes.
our colleagues appearing for the state and the other respondents proceeded to the Court of Appeal.
Yes.
And as we meet this afternoon, we understand that those conservatory orders were set aside. So, my lord, my ladies,
Yes.
you will recall our argument that time that we would not want this matter to be reduced to an academic exercise. Our fear then, and that fear remains valid, was that the National Treasury now obviously feel liberty to proceed and complete this transaction.
Yes.
But you also note that their lordships, the appeal court judges, also made it clear that the mandate of this court
Yes,
is not interfered with, and that you, upon hearing our submissions today, will be at liberty to make a decision we believe will be in the best interest of this country.
yes,
So, my lord, my ladies, we argue that the shares, subject shares numbering over 6 million, I think the precise figure is 6,009,814,200, comprising as they do complete
Yes.
total 35%. Now, the Kenya government shareholding, if this transaction was to go through, will be reduced from 35% to a paltry 20%.
can you hear me?
Yeah,
Pastor, I cannot hear you.
you can hear me, my lord?
Yes, now
Yeah,
I
you
can
can.
hear you.
Thank you so
are
much.
saying,
And therefore,
Yes.
the reduction from 35 to 20%, reducing therefore the Kenyan government shareholding to a minority. In fact, they will lose even the number of seats in the board. And the country gets to a situation where the respondents become, or some of them at least called upon, still remain a little bit at sea on exactly some of these relationships. And I know, my lord, my ladies, will be able to demystify these shareholding relationships, but the respondents, it's billion, huh?
6 billion shares.
6 billion, wow. My lord, my ladies, I'm corrected. It's not 6 million.
Yes.
It's 6 billion. 6 billion
6
shares.
billion.
6 billion shares.
Okay.
So that the respondents then become monopolistic, almost near monopolistic. And my lord, the Privatization Act number 18 of 2025
Yes.
at Article 22 D
Yes.
and E, 22 sub Article 2 D and E, the Cabinet Secretary is supposed to take into consideration, among other issues, and we want to highlight just two: the national security interests of the country at D, and at E, the need to avoid a privatization that may result in a monopoly.
Yes.
My lord, my ladies, we argue that the shares have been grossly undervalued
Yes.
and we rely on the expert opinion of Mr. Nyakera, believe this has not even been controverted.
Yes.
And so, secondly, my lord, my ladies, our argument is that the transaction advisors
Yes.
were irregularly procured without any competitive bidding.
Yes.
Our third point, my lord, my ladies, is that the expected sale proceeds, that using the expected sale proceeds as revenue contravenes Articles 209 to 214 of the Constitution.
Yes.
My lord, my ladies, the Cabinet Secretary failed to submit to the National Assembly a privatization program contrary to Articles or Section 22, I believe, Section 22, 2 of the Privatization Act.
Yes.
My lord, my ladies, we also argue that there was absence of public participation, a cardinal requirement in our country as it is today.
Okay.
And then fifthly, my lord, my ladies, failure to consider national security interest. In the sessional paper, as I said earlier, in breach of Section 22(2)(d) of the Privatization Act of 2025.
Yes.
Security, my lord, my ladies, is critical. This country is gearing itself for an election year next year. Transmission of election results normally is done through the telephones, the SAFARICOM and all. Never mind, my lord, my ladies, that sometimes they've been misused to give information regarding the now notorious abductions that have been visited upon the population of this great nation.
Okay.
So, my lord, the many agents, mama boggers who rely on or do their transactions in the millions, we had occasion to highlight that, my lords, my ladies, in our earlier submissions.
Yes.
We stand to suffer a measure of being dispossessed of this vital national asset, which will now clearly be foreign owned. Through the SAFARICOM group.
Yes, continue.
My lord, my ladies, I now yield the floor to Council Lempa to continue with the highlight.
Right.
I thank you.
Yes,
Okay, thank you very much, Senior Counsel. Lempa, and be precise and do not rehearse what you have already written. Give us the specific details which you think that would require our attention.
yes, thank you.
Lempa, continue on that basis.
Thank you, my lord, my ladies. Our petition, our amended petition is dated the 22nd day of April, 2026. It is supported by the affidavit of Tony Gachoka,
Yes.
dated the 16th day of June 2026. For the affidavit.
Yes.
My lord, it is also supported by the affidavit of Irongo Nyakera. Irongo Nyakera, I'll get the date. I'll get the date, my lord. And the submissions, our detailed submissions, dated the 16th day of June 2026. My lord, and before I proceed, I would like to bring to your attention, and under section 60 of the Evidence Act, that this court should take judicial notice that today SAFARICOM share was selling opened at 34 shillings and 40 cents. 34 shillings and 40 cents. That is judicial notice. And therefore, courtesy of your conservatory orders and the status quo orders by Justice Mugambi, your brother, this country has been saved of 2.4 billion shillings today, the money that John Bandigongo and Dorcas Oduor Agik Odong wanted to throw away. The Lord, without necessarily rehearsing on what my senior counsel has said, our submissions have a number of parts. We have the factual facts from paragraph 1 to paragraph 57, where we begin the analysis. But my lords, my ladies, we would like this court to take close attention to paragraph 2 of the written submissions, where the divestiture sessional paper states that they would want, or the objective of this divestiture, of this ignominious divestiture, is to raise revenue. My learned senior counsel has elaborated that the Constitution under Part 3 does not allow George Badingongo and Dorcas Agik Oduor to raise revenue using Part 3 of the Constitution. That is in paragraph 4. My lords, my ladies would also like you to pay closer attention to paragraph 5, where the sessional paper in paragraph 1.72 describes the would-be purchaser, the said shares of Vodacom Group, the seventh respondent, a foreign entity wholly owned and controlled by unknown shadowy persons. Watu ambao hawajulikani, shadowy persons. While
are you referring to submissions?
Yes.
Petition?
Submissions.
Submissions.
Yes. Paragraph.
Do you mind repeating what the Constitution does not permit?
The Constitution does not permit the state to raise revenue using Part 3 of the Constitution. It is well elaborate. It will come clearer as we go to specific details to that. But we are saying that on paragraph 5, the first respondent sessional paper, which is paragraph 1.72, describes the would-be purchaser of the said shares as Vodacom Group, which is the seventh respondent, as a foreign entity wholly owned and controlled by unknown shadowy person. While, on the other end, the press release dated the 3rd day of December 2025, which is annexed to the affidavit of Tony Gachoka, of the supporting affidavit dated the 22nd day of April 2026, projected the 8th respondent being the Vodafone Kenya Limited, as the would-be purchaser. They are introducing a purchaser by a press release, not in the sessional paper itself. Along, going down there, it is very clear that the way the respondents have treated this particular divestiture it's shrouded in mystery. The Lord, my learned colleague, my learned senior counsel Kalonzo Musyoka has said that indeed the expert evidence that is attached to the affidavit of Nyakera Irongo, IN1, is not uncontroverted, my Lord. My Lord, we wish to submit that while expert evidence is not binding on court, while a party wishes to challenge expert opinion on a technical issue, the ordinary and proper course is to adduce contrary expert evidence and mere assertions by counsel or lay witnesses, like John Badingongo is a lay witness, like Dorcas Odur Agik is a lay witness, are generally insufficient to displace a properly founded expert evidence. So that the question we pose, is the evidence of Irongo Nyakera a properly founded expert evidence? Yes, it is. Is Dorcas Odur Agik an expert witness? No, she is. She isn't. No, she isn't. Is John Badingongo an expert witness? Indeed, he is not. And therefore, we urge this court and we submit humbly that you treat the entire expert witness by Mr. Irongo Nyakera, who is a financial engineer, as uncontroverted. And the uncontroverted evidence, my lords, my ladies, is nothing but evidence of how the state has undervalued the shares of SAFARICOM company, the shares that they hold in trust for the people of the Republic of Kenya. SAFARICOM is not your ordinary telecommunication company. It's a strategic sovereign property whose divestiture cannot be done at the speed that John Badingongo and Dorcas Odur wants this court to adopt. My Lord, in our part B, we have raised the following questions for determination: whether the government can use Part 3 of the Constitution of Kenya and Section 74 of the Privatization Act to raise revenue as per the objective of sessional paper number 3 of 2025. That is well elaborated, and I don't wish to regurgitate on what has been written. It is well explained from paragraph 31st all the way to paragraph 57, with well cited cases from both the local jurisdiction and international jurisprudence, my lord. I think we have quoted the case of South Africa to support how this government or this particular regime is not allowed to create its own way of raising revenue outside of the Constitution, Article 209 of the Constitution of Kenya 2010, which some of the proponent of this particular divestiture opposed vehemently. The Constitution of Kenya 2010. As to whether the proposed sale of government shares in the 6 respondents violates Article 1 because of the sovereignty of the Kenyan people, Article 10, people participation, and in people participation, my lord, paragraph 76 is very clear. And it is even very sad that John Badingongo did not conduct public participation in his Suba county, so in his Migori county where Suba constituency is. He did not. While we could actually forgive him for not conducting it where I come from in Narok because it is there, and Lamu. But of course we know these are traditionally marginalized counties. But John Badingongo did not even conduct people participation in his own county. I don't know where Odur comes from. Maybe my good Richard Marwa can tell me, but I suspect he did not also conduct. She did not also conduct public participation. My lord, my ladies, we are highlighting 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 counties. 17 counties, no people participation was conducted there. And there is no village in this country where there is no M-Pesa shop. And we are being told, they are glowingly talking about how effectively we conducted people participation. It's a lie. And it is a lie by John Badingongo to Parliament and to this court.
Yes, continue.
My lord, from paragraph 104 is to whether the impugned transaction complied with the mandatory requirement of the Privatization Act 2003 and Public 2005 to 2025 and the Public Procurement and Asset Disposal Act 2015 and the applicable Capital Markets Authority. We have quoted cases and we have given facts as deponed by our petitioner and expert witnesses that this indeed was done wrongly. My lord, we proceed. We have quoted cases, we need not to rehearse them, they are in black and white.
Yes, Lebar, continue.
My lord, insofar as the divestiture of 15% of the Safaricom company is concerned, we are saying that the government does not, just as they were advised by the Law Society of Kenya and they ignored that particular advice, that they are not allowed to sell companies that are profitable. The only window that are given to them is for them to sell unserviceable, obsolete, obsolescent, and surplus assets, of which Safaricom PLC is not part of. My lord, in our paragraph 144, whether the transaction unlawfully undervalued the strategic national asset in valuation of constitutional principle governing prudent public management and protection of public resources. We have exhaustively explained that, and we have exhaustively indeed demonstrated how Article 10, Article 201 have been violated. Lord, I wish to refer this court to paragraph 149 on what the expert witness said about undervaluation. In 149, he says the transaction of Kenya price 34 per share is materially below the fair value of Safaricom PLC as at December 2025. My weighted central fair value estimate at Kenya shillings 57.90 per share, with the range of Kenya shillings 47 to Kenya shillings 77. The discount of Kenya shillings 23 or 43% represent foregone proceeds to the public of Kenya approximately Kenya shillings 143 billion shillings. That is what the Kenyan people whose shares are held in trust by the state is losing. Going to our paragraph 148, whether the intended transfer of effective majority control over the six respondent threatens Kenyan sovereign national security competition framework. My learned colleague, Senior Counsel Kalonzo, has explained that, but if you want to get the finer details, you get it from paragraphs 148 all the way. My lord, my ladies, you will be persuaded that the shares that we are talking about are floated in the Nairobi Security Exchange, and any one person can buy. My lord, we continue arguing that a secondary IPO would have sufficed. And our argument to this fact is that a secondary IPO would be even cheaper than the market price. And the Kenyan people, including the generation Zoomers or Gen Zs, who are not mature, by the time Irongo Nyakera, our expert witness, opened SAFARICOM IPO in 2007, were not mature. It is the desire of the Gen Z to have a bite at the cherry. Hata wao wapate nafasi ya kumiliki kampuni hii ya Kenya ambayo inamesewa mata na serikali ya Rais Ruto. Lord, disregard any persuasion that these shares, even if they are floated, will be bought by foreigners. At least they have disclosed that indeed we intend to sell this company to foreigners. And in those few remarks, I invite my good friend and colleague, Mr. Nzaku, to summarize.
Yes, yes, my ladies and lordship, I associate myself,
Mr.
Nzaku.
Zaku.
Yes, my lord. I associate.
Yes, can you summarize?
I associate myself with submissions by my senior colleagues, and what I'm saying is that, my lord, we are selling this company to a foreign entity. That is what it is desired. And to sell such a company to a foreign entity, it is a company which holds very sensitive data of the petitioner and 50 plus other Kenyans, or 50 million, who hold a Safaricom line. My lord, that information for every registered SIM card holder, it's protected under Article 31 of the Constitution, that such information, which is tied to the shares in Safaricom, cannot just be transferred to a foreign entity. This court, differently constituted, and as recently as on 19th March 2026, in the case of Erastus Gura Othiambo versus the state, petition number E290 of 2024.
Sorry, are you introducing some new authorities that have not previously been cited?
I am guiding the course.
My lord, we're here to highlight submissions which rely on authorities to which we have had prior notice. He cannot just decide that he'll introduce his own authorities at this stage.
My lord, my learned colleague, Mr. Zaku, is an officer of this court, and he cannot be
Zaku.
gagged. He cannot be gagged from
Zaku.
introducing an authority.
Yes, my lord.
Zaku,
Yes, my lord.
Zaku, did you find that authority?
That, my lord, is a recent authority. We've not filed it, but it's a key authority in this matter. That the court cannot ignore it. This is a court of law,
So-
and it's guided by
No,
the law.
we have noted it, but don't submit on it because the other council will not have an opportunity to reply to what you are saying.
Very well.
Continue on the other aspects.
My lord, I've said that digital data held by SAFARICOM, it's an information that cannot be transferred to an foreign entity, and as such, that would be my submission as regards that issue of data protection.
My lord,
Is that all, Zaku? You are completed, yes?
yes,
That's all. my lord.
yes, and to cap it,
Okay.
my lord, my ladies,
Yes? That's
Okay.
Senior Kalonzo?
yes, my lord, yes, my lord.
Okay. Then in 3 minutes?
Yeah, to cap it, my lord, my ladies, we want to make it very clear, perhaps, not even a matter for this court to note, but this matter is of great national interest. And 1 year to an election, my lord, my ladies, and taking into account what I earlier noted, the granting of the application by the respondents, setting aside the conservatory orders issued by this court, and being apprehensive of the necessary actions, next actions, my lord, my ladies, we should not take it against us when we issue statements on caveat emptor. Let the buyer be aware. All of this because national interest must be protected. We managed to stop the sale of the Jomo Kenyatta International Airport until President Ruto himself had to come out and say, stop it. I want to invite him to consider the same statement in view of the great interest this matter has evoked. Because my learned friend wa Tanzania anamuita wakili msomi. Wakili msomi mwenzangu, anawaita majina yao, lakini ukweli ni kwamba they serve under one authority, the President of the Republic of Kenya. I invite him to exercise prudence and high consideration of national interest. His predecessor, Uhuru Kenyatta, could not have dared touch SAFARICOM. We rest our case, my lord, my ladies.
All right. Thank you very much. There was another petitioner.
Yes, my lord.
Yes, Kiara, do you wish to
Kahara
make
Masharia,
any
yeah.
submission? And do not repeat what has already been stated, eh?
Yeah. Give me like 2 minutes, my lord. I read it.
2 minutes.
Yeah. I want thank this court because previous orders. na niko hapa kuunga mkono hii petition ya E051 na niko na huzuni my lord, kwa sababu wakati tulienda serikali ilienda kwa Court of Appeal,
Yes.
sikusaviwa na the relevant documents na nika complain, but they proceed to the matter in the Court of Appeal. Nimekuja hapa leo kwa kulia nikisema na nikiomba koti leo mchana ya leo, Safaricom is our heritage in this country, our brand that ikiuzwa iende kwa nchi ya kigeni hatutaweza kuipata tena. So kwa leo naweza omba koti ama niseme niko hapa kama Mkenya na nimekuja nikiwa binafsi nikiomba koti isikie ile kilio ya Wakenya wengine milioni 50 wenye hawana uwezo wa kufika mahali hapa. Sina mengi kwa leo, but naweza omba koti isikize hiyo ombi. Asante.
All right. Asante Saidi. So is Ogola here now? Professor Ogola, are you here now? Right. Professor Ogola is not here. So I think now we'll now go to the
Lord,
respondents.
I'm told Professor is on hold, is waiting to be admitted to the lobby.
There's nobody in the lobby. I'm the one who is admitting people, and I've admitted everybody. I've admitted everybody. I'm the one admitting the people. And I keep on admitting while we proceed. So in which lobby? Because he's not in my lobby. So I think we assume that he is absent. After all, you have made very extensive and profound submissions on the entire case. So we proceed now with the respondents. John Ohaka, and also be brief, because we are going to read the submissions which have been filed and which we find to be quite detailed and comprehensive. John?
Thank you very much, my lord. Your leadership. I see that Kalonzo Musyoka Senior Counsel has departed. We have listened very carefully to the case of the petitioners.
Yes?
We have given consideration to the submissions as well as to the matters put forward in the amended petition and the supporting affidavits. My lords, the respondent's case is simple and straightforward.
Yes?
In our respectful submission, the petitioners have built their case on the wrong legal foundation. They ask this court to treat this matter as a privatization program falling under the Privatization Act, and simultaneously ask that you treat it as a public procurement matter falling under the Public Procurement and Assets Disposal Act.
Yes?
My lords, both of those acts, at section 4 of each of those acts, exclude the sale of shares from the ambit of those acts. and we have set out the precise provisions in our written submissions.
All right.
It is difficult to understand why the petitioners choose to ignore the statutory route created by Parliament for the sale of shares in a government-linked corporation.
Yes.
The first duty of this court, therefore, my lords, your ladyships, is to identify the correct statutory route for the sale of these shares. In our respectful submission, that is section 87A of the Public Finance Management Act.
Yes.
Section 87A requires both cabinet approval and approval by resolution of the National Assembly, both of which have been met. So that, my lords, your ladyship, the court does not need to invent a further statutory route when Parliament itself has prescribed the route.
All right.
Therefore, the reference to Section 163 of the Public Procurement and Assets Disposal Act about ordinary disposal of obsolete, unserviceable, or surplus assets is of no assistance to the court, because it is not the route for the sale of a block of shares such as what is before the court. In our submission, once the court comes to the conclusion, as it must, that Section 87A is the proper statutory route, then a lot of what is before the court will fall away.
Yes.
Because, my lords, the petitioners cannot insist on an illegality being perpetrated by the respondents by insisting that the matter falls within a legislative architecture which Parliament itself has deliberately excluded.
Yes, continue.
The next issue we want to deal with, my lord, relates to Treasury's role in revenue raising and Treasury's authority to raise revenue or to mobilize non-tax revenue. The submission has been made that Articles 207 to 214 under Part 3 of the Constitution do not provide for the sale of shares as part of the ways in which government can raise revenue. My lords, Lords, that is a superficially attractive argument, but it is again a misconceived argument. Article 209 to 214 regulate taxation, charges, borrowing, guarantees, and public debt. But they do not say that government may never raise revenue from an investment. Indeed, my lords, all the court has to do is to go one article down, Article 206, which relates or recognizes that money raised or received by or on behalf of the national government may or should ordinarily be deposited in the consolidated fund unless a statute prescribes otherwise. Why would Article 206 provide or recognize money raised or received by or on behalf of the national government unless the Constitution itself allowed the government to raise revenue other than through taxation?
Yes, continue, John.
Article 206, my lord, is then given life or architecture by the Public Finance Management Act. Sections 11 and 12 of that act then give the Treasury the mandate to formulate macroeconomic policy, to manage public debt, to mobilize resources, and to manage public finances. If the petitioner's construction of the Constitution, limited to Articles 207 to 214, was to be accepted, then it would render Section 87A of the Public Finance Management Act completely meaningless and would significantly erode Article 206, which itself recognizes that government may raise revenue. As my lord, your ladyships will appreciate, the Constitution requires us to give a purposive interpretation to its provisions, not an interpretation that would result in the negation of various pieces of legislation which have been enacted to give effect to the Constitution.
Yes.
The third issue we want to deal with relates to the attack on the cabinet approval, the parliamentary approval, and public participation. My lord,
Yes.
the transaction has been alleged to have been conducted secretly in an opaque manner and without the requisite adherence to the provisions specifically of Article 10 of the Constitution.
Yes.
Well, we have demonstrated in the 3 affidavits sworn by the Cabinet Secretary
Yes.
that a sessional paper and accompanying explanatory material went to the National Assembly subsequent to the Cabinet approval. The Joint Committee of the National Assembly considered the sessional paper, undertook extensive public participation, and the National Assembly approved it by resolution.
Right.
We have set out, my lord, 78 stakeholder institutions were engaged. Public participation forums were held across more than 30 counties. 32 sittings considered the valuation, the identity of the purchaser, questions relating to employment, governance, competition, consumer protection, data sovereignty, and national security. It is not the law that every objector who presents his views must have those views embraced unconditionally. The test, and I need not remind your lordship, your ladyship, the test is one of reasonableness. We have given you the Supreme Court's decision on British American tobacco for the proposition that public participation must be real, not illusory, and must provide reasonable notice and reasonable opportunity. In our respectful submission, that threshold has been met.
Okay.
There have been allegations of fraud against Parliament. No particulars have been supplied. And those allegations have not been proven. It is not sufficient to place rhetoric before the court and make allegations of such a serious nature as fraud. Fraud, as we know, must be pleaded with particulars and must be proved.
Jody, you should be winding up, eh?
I am making progress towards winding up. Look.
Yes.
Let me next deal with the question of pricing and valuation. Because clearly, this is at the center of the petitioner's case. But it is also where the case is most ambitious, but least proven in our respectful view. What the petitioners ask this court to do is to sit as a valuation tribunal. This court is not a valuation tribunal, neither is it a valuation committee. The court's role is to assess the legality of the transaction based on the material placed before it. Mr. Lempar, to his credit, has looked at the share price this morning.
Actually bought some shares. I bought.
He bought?
Yes.
Oh, he's even bought the shares this morning. Congratulations.
Yes?
And referred you to section 60 of the Evidence Act. I need not remind the court that the material time is December of 2025, when the transaction was contemplated and sought to be entered into by the government. Share pricing is dynamic. It is affected by numerous factors. And if the petitioners had not interfered with this transaction through the launching of this petition, to which they're perfectly entitled,
And deserving.
this purchase price would have come in 6 months ago.
Yes?
So it is not sufficient to cite today's price and allege on that basis that there is an undervaluation. Neither is it sufficient to ask that one expert's opinion be preferred over the valuation commissioned and relied upon by the government. The court's role is to determine the legality of the sale, taking into consideration constitutional and legislative provisions, and to determine whether the price in the circumstances agreed by the government is so abnormally low as to point to perversity by government. In our respectful submission, the evidence placed before you by the Cabinet Secretary is to the effect that professional transaction advisors who are engaged, they considered all the factors, they had consideration to the numerous valuation methodologies, and they advised the government on what they considered to be a reasonable price with a premium based on the identity of the share in the proposed purchaser. In our submission, that price does not disclose any illegality. We have placed before the court comparative jurisprudence, specifically the decision of the Supreme Court of India in Balco Employees Union versus Union of India for the proposition that the court does not determine whether the valuation committee's price was correct, but examines whether proper procedure was followed and whether the price was arbitrarily low and unacceptable. The petitioner's expert opinion is not proof of unconstitutionality. It is at most, your ladyship, my lord, a different professional opinion. Beyond offering his opinion on what the price ought to have been, Mr. Nakera has proceeded on the assumption or on the theory,
Yes?
on the theory that the price would be higher if M-Pesa was to be carved out. But M-Pesa is part of SAFARICOM. It is a unified company. It is not being sold separately.
Yes?
And the suggestion, therefore, that a higher price would have been obtained is based on a faulty theory that we submit this court should reject. In the end, my lord, your ladyship, the petitioners have not proved an undervaluation. They have just proved that they would prefer a different model. That is not sufficient to override the cabinet approval and the National Assembly's approval, both of which are integral to Section 87A of the Public Finance Management Act. Lastly, let me deal with the issues relating to data sovereignty, national security, Articles 35 and 65, and the question of competition.
Yes?
All of these arguments, my lord, proceed on a mistaken basis that sovereignty, data protection, national security are preserved by shareholding. But the sale of these shares does not suddenly dissolve Kenyan municipal law. Sovereignty is exercised through law. SAFARICOM will continue to be subject to the Competition Act, to the Kenya Information and Communications Act, to the Data Protection Act, and to the license conditions imposed upon it by the various regulators. And this does not depend on its shareholding. In any event, the proposed purchaser of Vodafone Kenya Limited is a Kenyan incorporated company. Is a Kenyan taxpayer and is subject to Kenyan law. There is nothing in the law to suggest that the sale of these shares to Vodafone Kenya Limited and the reduction of government shareholding would suddenly diminish SAFARICOM's compliance with the myriad of statutes that this country now has to police the different aspects of our lives.
Yes?
The reliance on Article 65 is misconceived. It is about land holding. There is nothing about this case that relates to the sale or transfer of land. And the less I say about that, the better. In any event, foreign shareholding in listed companies is permitted by Kenyan law.
John, now I think you should conclude, eh?
Yes, I'm concluding. My lord, you allowed
Let's conclude.
you allowed the petitioners back and forth between
we
the
took less than
different
30 minutes.
council, and I'm just trying to wind up the 7 respondents that I present their combined case. My lord, in the end, when you break down the petitioner's case into its different components as a legal proposition, not as a political proposition, as a legal proposition, it is a disagreement about policy. It is a disagreement about the policy that government has chosen to follow with respect to revenue raising. No illegality has been demonstrated. Policy, my lord, is for the executive and the legislature. Legality is for the courts. Once you find, as I am confident that you will, that no illegality has been shown or demonstrated, it will be clear that the prayer sought must be declined. We ask that you refuse those prayers and that you dismiss the petition. I most oblige.
Okay, thank you very much, John. And now, a word of caution that you don't repeat what has already been stated. But if you give us something in addition to, we will really appreciate. So who is next?
Hello, with your
Yes.
permission, Mr. Muganda is online, so maybe I will start. And
Minister?
Mr. Musangi for the 6th respondent.
What order did you want to follow? Give me the order, then we
Mr.
go that way.
Muganda was for the 3rd, I believe. He's online.
Uganda.
We're
Uganda,
going
are you
in
there?
chronological order.
Uganda, are you there? Uganda? Where is Uganda?
Hello,
Uganda?
I can't hear
Uganda
him
is not
either.
responding.
Yes. Perhaps with your guidance, Lordship, Senior Counsel McCourt is present in court. Maybe we'll yield on seniority before I submit.
So you want Makot to go first?
Yes, please, if it pleases the court.
Mr. Makot, go first and be very brief without falling into that venue.
Can you hear me?
Repetition. Yes, I can hear you.
My lord, sorry, I had a bit of internet challenges.
Yes, that's Buganda.
Yes, my lord, that's Muganda. My apologies to the court. I lost a bit of my connectivity.
Yes, how many minutes do I give you without repeating what has already been submitted upon?
My lord, 15?
No, 15 is too much. John has spent quite a lot of time scanning through
So perhaps, my lord?
Giving details, yes. I give you 7 minutes because the others who are going to submit us. Uganda, go straight to your point.
My lord, maybe 10, considering I'm an independent client. My lord, the application or the petition is opposed.
Yes.
the third respondent has filed a replying affidavit dated by David Mugonyi EBS, dated the 2nd of June 2026.
Yes,
My Lord, we equally filed out their submission dated the 23rd of June 2026 and a list of bundle of even dates.
all right.
Yes, my Lord, to start with, in this entire, my Lord, 81 paragraph petition, there's not a single mention of the word the third respondent, either in terms of compliance or infractions. So as it sits, my Lord, the third respondent has been joined in the petition, but there is not a single mention of what it is meant to do that it has not done, neither has a single infraction been mentioned against it, to the effect that it is a passenger in the entire petition without a single prayer thrown against it. My Lord, what does that culminate to? The third respondent should be struck out, or the petition should be struck out for want of any prayers or orders against the third respondent. Number two, my Lord, the third respondent is a statutory institution, and my Lord, it is licensed, it is authorized to issue licenses. I will not belabor the court with the respective requirements. My Lord, I invite the court to consider paragraph 6 to 14, where the respective authority or power of the third respondent is well laid out.
All right.
My Lord, that authority does not end upon the issuance of a license. And in this instance, my Lord, the third respondent was approached by SAFARICOM via an application. My Lord, that application is marked as DM2 at paragraph 28, running all the way, my Lord, to paragraph 36.
Yes.
Upon consideration of the application, the third respondent issued a letter of no objection, which is at paragraph 37. At page 37, my Lord, of the third respondent's bundle of documents. My Lord, upon the issuance of that letter of no objection, there is nothing that would have been required of the third respondent to do in as far as the approval of licensing is concerned. And you have not been asked that this letter of no objection be rescinded, neither have you been told that it was illegally issued, neither have you been told that it was issued in breach of any law. To that effect, my Lord, no order has been sought as on the basis of the approval granted by the third respondent to SAFARICOM.
All right.
My Lord, the court has not been asked to interfere with it, and that matter rests there. My Lord, but even then, if the court was to have been asked for, my Lord, this approval for licenses, which, my Lord, the conditions are at running from page 1 all the way to page 27, my Lord, the authority and the power of the third respondent is continuing, and it does not end upon the issuance of a license or an approval. Section 84, Section 102, Section 102G, all vest the authority upon the third respondent to continue with an overriding supervisory duty, so that upon a breach of the licensing conditions given, the third respondent has power to intervene.
Okay.
My Lord, of importance is that the High Court does not have original jurisdiction with any regards emanating from any complaints from the issuance of the license by the third respondent. My Lord, I'll move to the second game. Merit of the petition. My Lord, Melania Senior Counsel has directed the court to the applicable law. My Lord, I will not want to bore the court, but I want to emphasize, my Lord, that it is important to read the preamble of the Privatization Act. My Lord, itself speaking. Go further to section 4C, my Lord, of the same Privatization Act. It expressly excludes transactions of such a nature from the ambit of the Privatization Act. The extensive reliance of the Privatization Act, as elucidated by Malani Senior, finds no right of any request by the court intervention because it's premised on the wrong law. My Lord, you've equally been invited to consider the Public Procurement Asset Disposal Act. My Lord, I humbly request the court to consider section 4D of the PPDA. My Lord.
Yes, Muganda.
Procurement or asset disposal with respect to which this act applies, acquisition and sale of shares or securities, fiscal agency by a public entity, investments such as shares purchased by corporate societies, state corporations or other public entities. My Lord, section 42D expressly excludes the intervention.
Yes, Muganda. Wind up. Uganda. 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 Uganda has run into trouble. Uganda, can you hear us? All right, I think let's move on. When he comes back, I'll give him 1 minute to wind up. So let's continue with the Makot.
My Lord, can you hear me? Yes.
Yes, Muganda, you're back. Wind up, please wind up, eh? Muganda. Muganda, we have lost you again. So I think let's continue. I'll give Muganda 1 minute to wind up when he has fixed his problem. So Makot, it's your time now. Muganda, you can mute.
Yes, please, my lord.
And Makot, I give you 7 minutes without repeating what has been stated.
I'll try to shorten it and not be repetitive. My lord,
Yes,
I'm
yes.
relying on my replying affidavit of 14th May, the submissions that we have filed of 25th June, and the list of authorities of the same date. I wish to associate the 8th respondent with the submissions already submitted by my learned senior counsel, John O'Haga. And
Okay.
I'll be very brief. I'm relying on my submissions, which I have paraphrased or set out 5 issues for determination, page 3 of those submissions. Some of them have already been covered by Mr. O'Haga, SC. Some of them I wish to reiterate for only one reason. A lot has been said about the 8th respondent being a foreign company or a foreign entity. That is not correct. The 8th respondent is a Kenyan company registered within Kenya and a taxpayer within Kenya. It happens to be at the current moment the largest individual shareholder of SAFARICOM and has been there paying taxes for 27 years. So it is not a foreign company, it is not some shadowy, shady set of characters, it's here. I think that point is important for everybody to understand. The other issues that I have raised, whether it's Article 227 of the Constitution, I think Mr. O'Haga has handled that. But the most important issue for the 8th respondent is that this amended petition has no cause of action against the 8th respondent. It ought to be dismissed. And that I've set out in the submissions, pages 3 to 4. The submission has no cause. The last issue that I will raise, because I want to expedite, though already O'Haga has covered, is the issue of costs. I would like to urge the court to dismiss this petition and to award costs to the 8th respondent. My lord, if we're going to pay out this large sum of money, we should get some of it back from petitioners who have brought a petition that has stopped or suspended our sale. for now.
Okay.
Most obliged.
Okay. Oh, thank you very much, Makot. We have noted the emphasis. Yeah, that's the way to go. That's the way to go. So the next one,
Lords, taking cue from
That is-
Mr. Makotis, Mr. Musangi, for the sixth respondent.
yes, Musangi. Continue.
As with my colleagues, we have filed comprehensive written submissions. Suffice it to say, I listened to counsel for the petitioners make a few points that warrant response. The
Yes.
first of which related to the so-called expert opinion. And this court was invited to conclude that there is a solitary expert before this court. My lords, the cabinet secretary has been referred to by all his birth names consistently. But what my colleague did not do was refer to his qualifications. And if you look at them in the introductory paragraphs, he is a fellow certified public accountant. So when he states his opinion, contrasted with somebody called Nyakera, who's a CPA, I think even if seniority were to apply, his opinion deserves some measure of respect.
My Lord, I
That's
hate
number
to
one.
interfere
I didn't
because
interrupt Mr. Lempa. I
the,
would
the,
appreciate
the CV
not
of
being
Mr.
interrupted.
My Lord, the CV has
I
not
would
been
appreciate
provided.
not being interrupted.
Lepa, you'll have your time to reply. Note that down. You reply.
Thank you, my
your
lord.
Time of reply.
And he does have a
Yes.
reply on
Yes,
point.
continue, Musangi.
Let me continue. My lords, the second thing about opinions is everybody has them. Everybody. That is why the framers of our constitution were very careful to incorporate something called public participation. This court will ask itself why Professor Frederick Ogola availed himself of the opportunity to participate in public participation. It's on record in this court. And Mr. Nyakera instead chose to come and do public participation in court. This is not the forum for it. He has not sworn anywhere that he was denied an opportunity to express his personal opinion when Parliament opened the dates for public participation. It is not open for anybody to come before the Constitutional Court and open the forum for public participation. That's why nobody is cross-examining him, because that's just his personal view. And when it comes to pricing of a publicly listed company, and again, Mr. Lempa told you about today's price, what he did not tell you was in the documentation filed before this court, it is shown that they took a volume-weighted average price over an extended period. Why is that significant? Because, my lords, it is naive to take a snapshot of 2 minutes of trading on the 29th of June and say that that is indicative of price. Quite apart from the fact that this court is not a pricing expert and cannot be invited to become a pricing expert. My lord, every day when Safaricom trades in millions of shares, a lot of experts look at it, and some buy and some sell. The fact that they are buying and selling at that price is their opinion of the value at that material time. And the fact that the price moves up or down is also proof that opinions vary as to what is the right sale value or the right buy value. So this court should not be taken on that expedition to venture into why is the price this or that. Finally, on valuation, what the petitioners forget is that this transaction has two components. Number one, price, And number two, a prepayment of dividends of 44 billion shillings. They can tell you about price morning, noon, and night, but they don't mention for 1 second that there is material value to the prepayment of a dividend from this particular investor. The people who paid 33.50 and 34.20 today morning were not prepaying dividends. They were just buying a naked share. Enough said about that, my lords. But that submission has absolutely no merit. My lords, you were also extensively told about Gen Zs who weren't able to invest in 2008. My lord, what you are not answered on, or the issue that was not addressed, was the share trades every single day. The very same investors can buy this share readily on the open market today. So they have not been denied access to the share, and I think Mr. Ohaga touched on this. So the submission about a secondary IPO, apart from the fact that it is nowhere in the petition to my knowledge, has absolutely no merit. Finally, my lordship, from a governance perspective, data sovereignty has been covered, security has been covered. Mr. Lempa talked about, I think it was Senior Counsel Kalonzo Musyoka, talked about losing directorships. If you look at the approval documents of this transaction, one of the conditions it is proceeding under is that there will be no change to the board structure or the governance structure and operational structure of the company. So Parliament was alive to the protections needed. The Capital Markets Authority, alive to the same. The Competition Authority, alive to the same. The Office of the Data Protection Commissioner, alive to the same. This court is being invited to sit in the shoes of the regulators and Parliament at the same time and review the transaction on merit. These specialized institutions have all been given either a statutory or a constitutional role to play in this transaction. And they are playing their role. You have not been told of a single illegality in the delivery of their respective mandates that would invite the intervention of this court. I rest.
My lord, you're muted. Oh, thank you for that. Now I'm saying the next person. Who is next?
My lord, can you hear me?
Yes, that's Aisha.
Yes, this is Mrs. Abdallah for
Yes.
the seventh respondent, my lord.
Yes, I also give you strictly 7 minutes. If you can do it less than that, the better.
I will try my best, my lord.
Okay.
We are relying on our grounds of opposition dated the 25th of May. And our submissions and list of authorities of the 24th of June.
Yes.
My lord, there are a number of issues I just wanted to clarify because unfortunately, the petitioners have continued to make grave misrepresentations even in the face of documentary evidence to the contrary. I had my learned friend, Mr. Lempa, describe the seventh respondent Vodacom Group as owned by unknown shadowy persons. Nothing could be further from the truth. Vodacom Group is majority owned by the 12th respondent, Vodafone PLC, and that is publicly traded on the Johannesburg Stock Exchange. To say that Vodacom Group is owned by unknown shadowy persons might suggest that a company like SAFARICOM, in a similar situation, that is trading on the Nairobi Stock Exchange, because of the purchase today by Mr. Lempa, has suddenly acquired unknown shadowy shareholders. It's not true. Because we disagree on policy does not make us shadowy. The second point to bear in mind is that SAFARICOM has been in existence for a period of time throughout which both the government of Kenya and the Vodacom Group as an indirect shareholder through its Kenya subsidiary have been large institutional shareholders. During that period, the government of Kenya's stake has reduced from 60% to what it now is 35% before this share sale agreement. And the eighth respondent, which is a Kenya incorporated company, holds 40%. It is not true that the largest institutional shareholder, the eighth respondent, is in any way a foreign company, and that evidence is uncontroverted. I don't want to repeat the argument on the law, but my lord, we have struggled as buyers to understand what is the actual complaint placed before this court today. We have had many inconsistent arguments. The first argument is that the government of Kenya cannot sell shares for revenue. And yet we know that in 2008, there was the first IPO. So we are wondering, what happened? Why is it that it could do it then and it can't do it now? Then we have also had today a suggestion that it would be better, instead of allowing this transaction to proceed, to instead have a second IPO, which means, of course, then there cannot be any in principle objection to the actual divestiture. So then we come to perhaps what is the real complaint. There's a suggestion that the divestiture cannot go to a foreigner. First of all, there is no bar. There is no bar. Publicly listed shares are available on the stock market to those who wish to avail themselves, taking advice or not taking advice. There is no suggestion that SAFARICOM shares cannot be bought or sold by foreigners. And then, to repeat a misrepresentation that has been presented repeatedly and in social media, the eighth respondent is not a foreigner, it is a Kenya corporate, subject to Kenya laws. And it is the counterparty in the share sale agreement. Then it looks like there's another complaint. You can sell potentially, if you sell to certain people that the petitioners like. You can sell potentially to a Kenya tick, that is the eighth respondent, great. Oh, but you cannot sell at the agreed price. Why? Because somebody or some people have disagreed. Some people think the share price should be lower. Those people tend to be on the purchaser side. There is actually evidence to support a lower share sale at the time this transaction was negotiated. And then some propose a higher price. And that is the point of a freely listed stock market, that it is subject to market movements. But I think it would have been important for the petitioners to clarify what is their actual complaint, because they cannot on the one hand say SAFARICOM cannot be owned by foreigners. That's number one, is not stated in our constitution and is not the issue before the court today, because it is very clear that the government of Kenya, on the one hand as seller, is selling to the eighth respondent, on the other hand as the Kenya company. So I don't know why we're talking about foreign entities. This court itself, in an earlier ruling, an interim ruling, recognized the distinction between a company, its directors, and its shareholders. That distinction is an important part of Kenya law. Kenya law, which this High Court is required and mandated to uphold and respect. So that when we look at the public importance and the public interest, we cannot use it to fundamentally change the nature and character of the sale, which is an arm's length commercial transaction, freely negotiated by the seller, the government of Kenya, and on the other side, the eighth respondent, Vodafone Kenya Limited, both subject to the Kenya Constitution and Kenya laws, at a freely negotiated premium price at the time. To look at the price today, had the price dropped at the today, there would have been no assertion by the petitioners that somehow the purchaser pays less. The fact that it might have risen does not change the agreed price. That is why we have a contract law where parties are held to what they agreed at the time. I would invite this court to look at our submissions and the grounds and agree with us that much of what has been complained about has nothing whatsoever to do with the seventh respondent, which is not in any way a state body or a public entity. It has not run the processes that are being impugned on, whether in cabinet or in parliament or with the general public, and is entitled to freely exercise its rights, its lawful rights as an investing shareholder in Kenya through its subsidiary and the long-term investment it has made in the
I shall
six respondents.
respectfully ask you to wind up now.
My lord, I am done, unless you have questions.
No. Thank you, Aisha. Thank you very much for that. So I think let's go to the next person.
Yes.
Who is next?
Your Lordship, Ismail for the 12th respondent.
Ismail.
Yes.
Ismail will be very brief and without repeating what has been stated.
Yes, thank you, Your Lordship and my ladies. So we have filed, similar to the 8th respondent, similar to the seventh respondent, we have filed grounds of opposition dated the 25th of May 2026, as well as our written submissions that are dated the 24th of June 2026.
Right.
Your Lordship and my ladies, I will not repeat, but most of what we are or we would be submitting in court has already been stated by my colleague, Mrs. Abdallah. Your Lordship, Your Lordship and my ladies, I would like to make the following points though. The 12th respondent was cited in the petition by Mr. Samuel Masharia in petition E836. In the amended petition that is in court, that was filed by Mr. Lempa's client and Professor Ogola, who later dissociated himself with his legal representation, does not mention anywhere the 12th respondent, Your Lordship and my ladies.
Okay.
Again, Your Lordship and my ladies, when you retire to consider our submissions, you will note that that petition filed by Mr. Samuel Masharia grossly offends the Anarita Karimi principles because it doesn't identify with to any degree of specificity how his or the people he purportedly represents, their rights were violated by my client, the 12th respondent. And what provisions of the Constitution have either been alleged with threatened with violation, or have actually been violated, and by what sort of conduct.
All right.
To that extent, I would associate myself quite strenuously with the position taken by Senior Counsel McCourt that the court should pronounce itself and award costs as against the petitioner who has cited my client, because your lordship and my ladies, we will be propagating a scenario where the courts are then going to be responsible for the backlog that is being complained of. There must be a sieving mechanism that the court must deter frivolous litigants from vexing parties who have absolutely no linkage to the cause of action that is being presented before the court. And the only way that the court can stamp its authority and prevent this sort of abuse would be to award costs against that party. So with those remarks and associating myself with the sentiments previously expressed, I would urge that the court dismiss the petition with costs and certainly dismiss the petition as against the 12th respondent with costs. Thank you.
Thank you, Ismail. Yes. We are now through with the respondents. Barasa, I'll give Moganda 1 minute to wind up.
Well, thank you for the indulgence. My Lord, 2 points.
Yeah, Moganda, 1 minute, please wind up.
Yes, my Lord. My Lord, on public participation, my Lord, it's important to appreciate from page 44 all the way to page 126 that all parties were given a chance. Of interest is our very own Professor Gola was in attendance. That's found at page 120 of the document filed by the third respondent.
That has been stated very well by Mr. Musangi.
I was just directing the page. I was directing you to the page with specificity. My Lord, my Lord, of importance, my Lord, is that Parliament was intentionally kept away from this petition. My Lord, I humbly request the court to consider the provision of Article 94(2), 95, 201. The power to legislate, the power to make the decisions of being asked was specifically vested in Parliament under the stated sections. And lastly, my Lord, when you look at the prayers in the petition, my Lord, they are internally incoherent. My Lord, they run from paragraph A to Q. They ask you to go by Parliament approval. Parliament has given an approval. Under the same thing, they ask you an order to prohibit the first respondent from selling. What is the exact prayer before courts? Number 1. Number 2, my Lord, not a single prayer has been sought against the third respondent. Why was it enjoined? I would ask, as has been stated by Senior Counsel McCourt, courts should issue in such an event where you drag a party, but you do not plead anything against them. And lastly, my Lord, these prayers do not find a basis in law. They are unsupported, they are incoherent, and the totality of the petition is that you do not understand what they want, because they've asked you to follow the law in ensuring that the law as stipulated under Section 87 is followed. That has been followed. What more is remaining for the court to do? I humbly pray, my Lord, that you find that this petition lacks merit in its entirety and it is fit for dismissal. I so pray, my Lord. Thank you.
Okay, thank you very much. Now I think we are through with the respondents. Lempa, I'll give you only 10 minutes. Reply straight to issues which have arisen. Don't bring new issues.
About 15 minutes.
About 10 minutes. About 10 minutes, go straight to the issues.
Without much ado, I'll go to costs that have been paid by my senior, Mr. McCourt, Mr. Muganda, and I think my Lord Jasbir Rai and Doctors for Life South African cases are well known that you do not deter public spirited individuals from defending the Constitution. Mr. McCourt, Mr. Ajawara and company wants they want laissez-faire where they violate the Constitution without public.
No, I'm sorry, my Lord.
Ajawara's advocate.
We have not violated the Constitution. I don't think there's been any allegation against Anjarwala and Kana as a law firm.
Lord,
so Loti, I think it should be tracked.
I said Ajawara and Kana advocate.
We will check that against the facts and the pleadings. He's just alleging. So
yeah, Ms. Abdallah.
Ms.
Abdallah said that they have not violated anything. I think she has construed against vertical and horizontal application of the Bill of Rights. Individual persons under Article 20 can violate the Bill of Rights. That is well settled law. Ismail. on jointer and non-jointer, it is not fatal. And for cost again, nataka niwaambie kwa Kiswahili nijaribu kwingine, public interest litigation, you don't get cost. Tafadhali utafute pesa kwingine. What is the complaint? What is the complaint, my lord, by Ms. Abdallah? She can go to paragraph number 72 to 81 of the amended petition. She will get the complaint there. My lord, you have been told that these are pure commercial commercial transactions. Safaricom shares are held in trust by the Kenyan government on behalf of the Kenyan people, including people in Narok and in Suba. My lord, you have been told that you disregard the opinion, expert opinion, and you have actually been told by Mr. Musangi that the expert witness is only a CPA holder. The CV talks on itself. Mr. Irongo Nyakera is a graduate of Oxford University, business administration. He actually a bachelor's degree. My lord, he even speaks French. If he was here, he would be telling them, the more the office of the Attorney General changes, the more it remains the same. Plus sachant, plus c'est la même chose. It's in clear or whatever. My lord, you have been told that that particular evidence, my lord, you have been told that the evidence, the expert evidence that the government proffered is what our expert on that point, my lord, we would like to refer you to paragraph 24 of the submissions, where we say the petitioner further intimates that the first respondent completely failed, ignored, neglected, and refused to advertise the transaction advisory services. And we have actually gone out of our way to say that they were procured, the KCB group that was procured against Article 232 on values and public of values of public service. My lord, on analysis.
Yes.
On analysis, it is the intention of the Attorney General to recharacterize this particular transaction as purely statutory. And we are saying, you refer to paragraph 38, where we have expressly stated very clearly that this is a strategic national infrastructure that cannot be limited to statutory control and regulations. Lord, we have also been told by, I think, my good colleague, Mr. John Morris Ohaga, that the Attorney General is allowed to raise revenue. We have actually gone and explained in paragraph 38 and actually gone out of our way in paragraph 47 to say that the American Constitution provides for what the Kenyan Constitution does not provide. We have actually provided comparative constitutional framework on how to raise revenue. That is on paragraph 47. I have already talked about violation of Article 232 on values and principle of public service, and the characterization of this particular divestiture to Article 87A. My lords, my ladies, read carefully, and I believe you have, and we are already confident that you have been reading our submissions. Paragraph 60 of our submissions, together with section paragraph 61, where we say the proposal of 15% of government shares in the sixth raises constitutional question of the highest magnitude, implicating not merely commercial consideration, but the sovereignty of the people of Kenya, the integrity of constitutional governance, the protection of strategic national infrastructure, and fiduciary obligation imposed upon state organs in the management and disposal of public assets. My lords, my ladies, I know you know the history of SAFARICOM. It started with Kenya Post and Telecommunication Company, where some Kenyan taxes were taken to form SAFARICOM before it was bought by before the IPO. My lord, and you have been told, before I forget, that Nairobi shares are normally floated in the Nairobi Stock Exchange. What my good learned friends are forgetting is that the pricing of an IPO is different from shares from the sale of shares in the Nairobi Stock Exchange, my lord and my ladies.
Yes, Lapan, have you finished?
Not yet, my lord. My 10 minutes are still.
Then what? Yes. Continue.
My lord, we have been accused of not proving fraud, of which we actually have proven how Parliament was how the Cabinet Secretary, Mr. John Badingongo, lied to Parliament. And in that we rely on paragraph 5. The first respondent sessional paper, paragraph 1.72, described the would-be purchaser of the said shares as a Vodacom group, the seventh respondent, a foreign entity wholly owned and controlled by unknown shadowy persons. While on the other end, the press release dated 3rd December 2025, and it is even annexed in the affidavit of T.G. Gashoka as the supporting affidavit dated 22nd, projected the 8th respondent as the would-be purchaser. So the would-be purchaser, number 8, was not in Parliament, and that's the fraud we are talking about. My lord, we have been accused of pursuing political interests, particulars of which were not given. At least we have given particulars of every allegation we have made. But my good friend John Maurice Ohaga says that we are pursuing political interests. We are not. And there is no single word, no adjective, no verb, no preposition, no proverb that has been proffered here to suggest that my client, Mr. Tony Gashoka, who is a well-known journalist, is pursuing narrow political interests.
Yes.
My lord, you have been told to compare the expertise of John Badingongo and that of Irongo Jakera. While we do know that Mr. Ngongo is not an economist, the CV of my expert witness is here. My lord, very interestingly, we even actually suggested to them that they cross-examine this particular expert witness, and they declined. And actually, in the Court of Appeal, they told the judges, Justice Patrick Omwenga and Justice Ajode and Mr. Justice Honorable Muchelule, that the expertise witness that you relied to write the conservatory orders were not cross-examined. I interfered. I actually interfered with the submissions of my learned colleague, Mr. John Maurice Ohaga, although I hate interfering or heckling my seniors. And as I tenor,
But you're doing it all the time. I don't know what he's saying.
I respect Mr. Makoko, I respect Mr. Musangi, I respect Mr. John Ohaga because Chinu Achebe says that a woman who started cooking ahead of the other has more broken utensils. They started practicing ahead of me. They have better experience than me. I rest my case. Unless you have a question that you want me to answer, that marks the end of my cross-examination. Submission.
Okay, thank you very much. The other Kehara, do you have anything to reply to? Yes.
Thank you, my lord. I read it.
Yes.
Nilikuwa tu nataka kusema kwa koti bwana Ismail anafaa withdraw that statement because in this country kila mwananchi ako na haki ya kutetea katiba, na ndio nimesimama na nikakuja kwa koti kutetea hiyo katiba, kwa sababu kuna wananchi wengi wangependa kufika hapa lakini hawangeweza. Nilijitoa muhanga nisimame kwa koti nitetee katiba yenye inatulinda sisi zote. Kwa hiyo ingine nilikuwa nataka kusema, kuna swali iliulizwa hapo, kwa nini Vodafone inagadamizwa kununua Safaricom na 208 iliweza kununuliwa na wananchi. Right now we have a 2010 constitution. Before Safaricom IPO in 2008 or even before, tulikuwa na the old constitution, na kila mwananchi ako na haki ya kununua hisa ya Safaricom. Kila mwananchi anafaa akuepewe power, na kila mwananchi anataka power. So tusifike pahali kwa kukandamizwa wa mwananchi wa Kenya apatiwe right yake, apatiwe ile the constitutional right. Even those foreigners kama wanakuja wakuja wanunue kama Wakenya wengine washapatiwa opportunity. Ni kwa hayo tu kwa leo, asante.
So the judge, Abredi, anything would you like to ask or get clarification upon?
Yes. Some clarification from Mr. Dampa. What is your take on Section 87A of the Public Finance Management Act?
My lady, if you look at the paragraph that I referred, the last one, on the Attorney General characterizing this as a purely commercial and statutory transaction, you would actually end up thinking that that is the right route, because that's what they said, that the route that Parliament has provided. And we are saying that the sale of Safaricom shares 15% to foreign entities is not only a commercial, your ordinary commercial transaction, but such an important national infrastructure that engages even Article 10. Because actually I listened to their submissions, and they were saying that we are attacking policy, forgetting that Article 10 joins or enjoins state organs and state officers while rolling out policy. And that's where we are saying that this is not your ordinary Article 87A. It cannot be limited to that, because the shares held by the first respondent are held in trust for the people of Kenya, and that is the reason why they were obliged to conduct public participation in almost all the counties. They actually even confessed that we did in almost that, assuming that 17 counties Safaricom transactions are never held there. It is not our submissions, or my answer to your question is that Safaricom divestiture of 15% of Safaricom shares is not a statutory controlled transaction. It's a constitutional issue, because shares held therein are shares held in trust for the people of Kenya.
That's well understood. What about the Privatization Act?
Privatization Act, we are saying that they abused it. If you look at paragraph, it's a paragraph dealing with privatization in our submissions, and we are saying that there was no even privatization policy that was rolled out for the divestiture of the 15%.
That question is in line with the submission that the provisions of the Privatization Act do not apply to sale of shares.
Yes, it applies in some way, but it cannot be taken in isolation. It cannot be limited to article the public management
Public Finance Management Act of 2012.
Thank you, Council.
Okay. And Judge Oya?
Thank you, Presiding Judge. I have no questions to the council.
Right. So I think we need now to give a date for judgment. Jaburiri, can you guide us in respect of that exercise?
Thank you, Presiding Judge. Before we pronounce ourselves on the question of judgment date, we wish to make some requests first. Is that we need parties to furnish the court with bound copies of those documents that we filed, which are quite bulky, in 3 sets. If that's not too much, we need them for purposes of a quick disposition. We have fast-tracked the hearing of this matter, and it's also incumbent upon us to fast-track the decision-making so that whichever way it goes, the parties then have the opportunity to ventilate further. Together with the bundles of authorities, you bind them together, especially those that cannot be printed by the court when they are too bulky. I hope that's not too much. Oh,
yeah, we'll discuss that so that
Senior Counsel is
we are able to assist another. Yes, Judge Aprili?
Now, Presiding Judge, we may have to consult on a judgment date.
Yes.
I will be on leave from 13th of July. But that does not stop the court from working. We continue working for information even when we are on leave. Not necessarily sitting in open court, but we write judgments and rulings we deliver them. So I think on the date we may have to consult as 3 judges before we give it to you, Council.
So we are agreeing that
we suggest that now that conservatory orders are being vacated, we be given an early judgment date to prevent the Attorney General from the mischief of rendering your judgment academic.
Exactly, we will be consulting and
So Judge Aburi, do we consent straight away or we give it some time and perhaps we communicate to them?
We take time off and we communicate to the parties.
Okay, so we communicate to them today, yeah?
Yes, and you do not have to wait here. We will.
Yeah, we communicate in the writing by way of directions today. So because we give this matter the seriousness that it deserves. But it is good that we go that way. I am on leave myself, but you can see I've sacrificed myself. The judge will go on leave, but I know she will also sacrifice herself to ensure that there is expeditious disposal of this matter. So allow us that latitude. We converge and discuss, but we give those directions maybe before the end of the day. But it's already 5, eh? Latest tomorrow morning. The elections will be there on when the judgment date will be.
My lord, this Kahara Masharia, nataka kusema tu kwa sababu sikuhusishwa kwa ile wakati wa Court of Appeal na ile consultancy order ililiftiwa, so nahofia tu kampuni itauzwa kabla hatujafikia wakati wa judgment, so nahofia sana.
Hata Lempa amesema hivyo.
Ni kwa sababu
tunakonsida yote alafu tutawapea tarehe.
okay.
Tunaelewa umuhimu wa kesi hii na pia the agency involved.
Thank you. Your Ladyship, and
All right.
just for clarity, we
So,
say the bound copies
yes.
will come by tomorrow. Tomorrow.
Yes.
Yes. So that they
Yes,
are time.
I didn't get.
We would like to supply the bound copies of documents by tomorrow, so that we don't impede the court's ability to deliver the judgment as early as possible.
Yeah, I wanted to come. That was the next issue. I was wrestling with the issue of judgment date. That is true.
Can we have 2
We'll
days?
give the communication latest tomorrow morning.
It's a lot of
This one
documents.
is a fair request. It's a fair request so that we are able to move with speed and without omitting any of the documents that you filed in court. So how soon can you do that so that you do not
Can we
impede
have
on the
it
time
end of day
we are
on
looking at? He's suggesting by tomorrow.
End of day on Wednesday?
End of day Wednesday.
Yes.
So what is the consensus? End of day Wednesday?
End of day Wednesday applies to all, my lord, petitioner plus respondents. So we
So
can have that
end of day Wednesday, and we are going to record that today as a direction that you supply the physical copies, bound physical copies in duplicate, because we agree. So I think let me now record those 2 directions. Can you mute unless you are addressing the court so that we minimize noise, So I've recorded that judgment date is going to be communicated by end of today or latest tomorrow by noon. So we want to be careful not to offend the rule against judgment on notice. And number 2, parties are to supply physical stroke hard copies of the documents filed in duplicate by the end of Wednesday, the first day of July. To supply, and let me add the court, so that I'm clear. So you supply to the court by end of day Wednesday, first day of July 2026. So I think that brings us to the, yes, Judge Amorim.
Before you close, you will also be receiving an email from the deputy registrar requesting you to send the
Yes.
Word documents of the file.
Yes. Okay.
In terms of petitions, responses, and submissions.
All right, Judge Amorim follow through and ensure that happens, And then parties and the legal counsel to respond appropriately. So I think it has been wonderful listening to the eminent arguments by each one of you. And I must admit that you have served the court well. We are not complaining, nor regretting anything, or any session that we have undertaken together. It has been such a wonderful and illuminating sessions from the legal counsel. and also from the police, those who are representing themselves. We also wish to say that that kind of service to the court will be rewarded one day in the books of eminent people, where you tackle issues dispassionately. And I would thank all of you for observing real decorum as required of you as ministers of justice. So thank you very much, everybody, and I wish you a great evening.
Thank you very much, my lord, the leaderships. I wish you a great evening. Thank you for your time.
Okay. Thank you. Thank you, John. All right. Now I will exit. See you, God willing, any other day. We interact in any other matter.
I'm much obliged.
Kwa nini hamkuniita?
John Morris Ohaga.
President, I remember people in their schools so that I need to go
John Morris Ohaga.